So I'm going to start off by looking at some principles that are key for me. And the first one is that we assume everyone in this room is capable. We would have to prove you are incapable. So you are capable. The second thing is that we in this society think self-determination is really important, so that we value that. And we have to sort of prove when self-determination isn't what has to be followed. We should have respect for the person, regardless of their capability. Even if they're incapable, we still need to think about what it is that they would have wanted when they were capable and respect them as people and ask them questions. And we always have to think of the least intrusive and the most effective interventions, and we really mustn't act beyond that. There are a whole bunch of laws around this, and the Healthcare Consent and Care Facility Admission Act is an important one from 2001. But as you will note, as I speak further in Jarrett, that they only brought in the Healthcare Consent Admission Act. They didn't bring in the Care Facility Admission Act. So we don't have that at this point, which has created a bit of a hole in the legislation. We have to get around that by using the Mental Health Act with extended leave for some patients to get them into a facility against their will. And we'll all be glad when that hole is covered. For thinking about the future, we've got the Power of Attorney Act and the Representation Agreement Acts. And if you haven't thought of the future and if you haven't planned, then you may be involved in the adult guardianship process. So what do I say to families or to patients? First of all, if you're capable, you can make your decisions yourself financially. There's no question about that. And you can think about the future, and maybe you want to make a standard representation agreement. And that's only if you've got a small amount of money and not a whole lot of assets, not a house, not other things. So it's a less degree of abilities in terms of managing finances, and therefore a lesser sort of capacity. If you want, you can also think about making an enduring power of attorney, so that if you did become incapable at some point, you would still want that person to be making decisions. So those are choices that you can make, and I think these are the choices that we should be encouraging people to make while they are capable, so that they don't have to come into these more restrictive legislations. When people are incapable, clearly if they had a Rep 7, that can be enacted, or if they had an EPOA and an enduring power of attorney, you could enact that. There's also such a thing as a pension trusteeship. Do people know what that is? If you just have a pension, and it's the Bloom Group right now around here. It used to be called the St. James Society. I'm not sure if the Bloom Group is provincial or not. But then there is also the possibility that if you haven't planned for a rep agreement or an enduring power of attorney, that you may need a committee. It used to be called committee for the public trustee. It's now called a standard substitute property guardian, and that is using the new law, the AGA Part 2.1, for the public trustee. It's not using the old Patient Property Act, and I'm going to mention a bit about that. But there's also the old law, the committeeship of finance under the Patients Property Act, and if you want to be a private committee, if you're a daughter and you want to take control of your mother's finances because she is not capable, you could apply to the court, you could have 2 medical opinions, and a judge will make that decision. So that's for finances. In the future, we hope that the Patients Property Act will be gotten rid of, and we will have guardianship of finances under the guardianship law, but we wait for the future to find out. What about personal decisions? Where you want to live, your health care, those kinds of things. Well, if you're capable, you make them yourself. You should be thinking, however, about what about in the future if you were not capable, then who would you want to make decisions? Or would you want somebody like a representative? A Rep 7, a standard agreement where there's a low level of capacity, or a Rep 9 where you really can understand what the issues are, and you would choose somebody to be making your decisions for you in the future when you can't yourself. Or, as of 2011, you could make a legal advance directive. I prefer them to think about representatives rather than just a piece of paper, and I would prefer them to think about advanced planning, knowing what they want and talking to their representative, but some of them have a real issue about wanting a legal advance directive. They want it written down. They don't want a person. That's what they want. So that's possible. If they become incapable then, we've got the healthcare consent law. And there's a temporary substitute decision maker available under the healthcare consent. Or you could enact your Rep 7 if you had one, enact a Rep 9 if you had one. I mentioned if you didn't have a Rep 9 which allowed you to be admitted to a care facility against your will, at the moment you might have to have the Mental Health Act and extended leave, or if you didn't have a committee. And the committeeship of person, again, is a court case, 2 medical opinions, and a judge makes the decision. In the future, we hope that they will bring in the admission to a care facility substitute decision maker. I dearly would hope for that because I don't want to continue using the extended leave, but it's necessary at the moment. And there would be, hopefully, guardianship over health and guardianship over person, getting rid of the Patient's Property Act. So for a Rep 7, there's just 4 words I want you to focus on in order to make a Rep 7. You have to have a desire, you have to be able to make choices, you have to know if you do it, that if you stop doing it, if you say you don't want it anymore because you're still capable, that things may change, and you have to have a relationship of trust. That doesn't say anything about understanding or appreciation. During power of attorney, there are a lot more specific criteria. I'm not going to go over all these. They're in the handout. I want to focus on something else. The Patient's Property Act, if you don't know it, is a very ancient law, and it had no real criteria. All it said was that you defined a patient as somebody with a mental infirmity arising from disease, age, or otherwise, who's incapable of managing his or her affairs. There's no criteria there. So there really wasn't a good way to standardize any kind of an approach. And the new guardianship laws actually do have specific criteria. They're much better. And in fact, the Ombudsman in 2013 didn't like the way we were choosing the public trustee. They felt that, in fact, there needed to be more rights for the patient. There needed to be a really firm assessment process, and there needed to be training for the healthcare staff. So they actually said, we're not just going to use the Patient's Property Act, we're going to use this Guardianship 2.1. And they defined it into 4 areas: determining the need, having an assessment, having a health authority designate decision, and then they also defined second assessments and reassessments. They also defined this component of a green light. And what that meant was that before anybody starts formally assessing somebody for managing their finances for the public trustee to take over, the public trustee and the health authority have to really look at it and see, is there anything less intrusive that is effective? And so let's avoid that if we can. So let's make it simple. If there isn't, then you can authorize a formal assessment. And if there's a formal assessment, the patient has to be advised of their rights. There's 2 components to that assessment, a medical and a functional component. The medical can only be done by a doctor, but the functional can be done by a number of different healthcare professionals who are allowed to do it because they're registered with their colleges and because they have training. The physician can do both, but it's likely in the future that other professionals other than physicians will do the functional component. The patient has to be given their rights, and these are the kind of rights that they have to be given before it begins. Then there is a specific capacity test. You remember the Patient's Property Act? None? Well, this is the adult guardianship test now, and it's been brought into the public trustee for the SPG. And in that case, there are several elements of understanding, and what I particularly like is the last one. You have to demonstrate that he or she is able to implement or direct others to implement the decisions or actions about their financial affairs, because we know that many people who had frontal kind of problems with dementia could tell you all about their finances, but they never did anything. But in this case, they have to be able to do something. So there are second assessments and reassessments. The representation agreement, you have to be over 19, and there are various things, I'm not going to go into it, to make it legal. And then the advanced directives were brought in 2011. Bottom line is they have to be able to understand the nature and the consequences of the document. We come to healthcare consent. Consent has to be specific to the proposed course of treatment in healthcare. You're either having your gallbladder out or you're having your heart transplant, but it has to be very specific to that thing. And valid consent relates to proposed health care. It's given voluntarily. It has to be given by a capable adult for which there are criteria. And it's a process which the adult has the opportunity to ask questions. So it's not just good enough to tell them stuff. They have to be able to ask questions. The test of capacity for consent is that they can understand the information given by the healthcare provider and that they can understand that the information applies to the patient's situation. I teach medical students all the time, and I tell them you can make somebody incapable by not communicating properly and not listening. So it's an important procedure. So the information that the healthcare professional has to give is the condition, the nature of the proposed healthcare, the risks and the benefits, and alternative courses of healthcare. And then there's this temporary substitute decision maker hierarchy. So if you don't have to make a representation agreement. In fact, the public trustee has a lovely document called It's Your Choice, and you can look it up on their website, and it talks about representation agreements. You don't have to have one if you don't need one. If you've got people you trust and lots of them, no problem. But if you don't, and you haven't chosen anyone, then this is the hierarchy. The first person on that hierarchy is the spouse, then the adult's child, and you can see it goes down. Finally, there's a person who's related to the adult by marriage, your in-laws, and the public trustee as the very last resort. So as I said, you can use the Mental Health Act to get somebody into a facility against their will. We don't like doing it. And the comiteeship of person is a court case. At the moment, it's 2 medical opinions, and it goes to a judge to make that decision. It's under the Patients' Property Act. In the future, maybe when the Guardianship Act is brought in, there will be a more standardized approach. I'm hoping so, and there will be more education required, just as it is with the public trustee.